Hello everyone, I'm Mugni Islam Chowdhury. I'm a barrister at No5 Chambers, and I've got with me
Anthony Corn, who's also an employment barrister at No5 Chambers, and I'll be supporting Mugni in this presentation.
And we're going to be talking about collective consultation for redundancies, which is obviously a very hot topic at the moment. So the first thing that we're going to be looking at, or the areas we're going to be covering, are when the obligations arise, the duties themselves and how we mitigate the risks for breach, penalties and enforcement for breach, special circumstances, and obviously the impact of COVID and the pandemic. Okay, so as you well know, in any redundancy, consultation is absolutely integral to a fair selection process. And collective consultation is required when specific conditions are met. And if you fail to follow the obligations, there are quite severe consequences. So we're only going to be looking at redundancy, although we do touch on TUPE and other aspects of collective consultation, but really this focus is on redundancy. So when do the obligations to consult actually arise? Well, the key legislation is in the Trade Union and Labour Relations Consolidation Act 1992, or the 92 Act as we all refer to it, and the duties to inform and consult. Those are triggered together. As soon as the obligation to inform is triggered, so is the duty to consult. And the duties are triggered, and the key section really is section 188, when there are proposals to make 20 or more employees redundant at one establishment within a period of 90 days or less. And we're going to be looking at each of those aspects as we go through this talk. So the first point we're going to look at is the EU dimension, which is quite important because all of this is derived from the Collective Redundancies Directive, which is an EU directive, and therefore certainly up until now, when interpreting section 188, it's important to understand the obligations under the directive because the European Court of Justice case law is relevant in interpretation, and the tribunal has to give it a purposive effect when it's construing the obligations under section 188. Anthony, I think you've got something to add to that.
Yeah, just a few things on that. There are a few areas where the Collective Redundancies Directive slightly differs from our domestic law, and we'll be touching on that. For example, under the directive, the duty may arise where an employer is contemplating redundancies, although we'll see that as a result of a Court of Justice decision, actually the distinction between contemplating and proposing is less significant than previously. There's also a slightly different definition of dismissal, and the scope of the directive, as we'll see, the type of people who are covered by it is slightly different from our domestic law. But of course, following the European Union Withdrawal Act, it remains to be seen how significant these differences are likely to be in the future and what impact, if any, European court cases are going to have on our domestic law. That's really another topic, but I just wanted to highlight it at this stage.
Thanks, Anthony. Okay, so what is a redundancy? That's obviously a very important question because the duties are only triggered if there is a redundancy within the meaning of section 195 of the Act. And the immediate thing you'll notice as soon as you read section 195, which I've put on the slide here, is that the definition is much wider than the section 139 Employment Rights Act definition we're all familiar with, which is a sort of a simple redundancy. So under section 195, it includes section 139 redundancies, but it also importantly involves business restructures falling short of section 139. So you'll be familiar with the fact that in lots of ET3s, you plead that there's a redundancy, or in the alternative, some other substantial reason being a business restructure. Well, it includes business restructures, but also dismissals arising from the introduction of new working practices, and we've got some examples of that, and also variations in terms and conditions through termination and re-engagement. Now, in light of the pandemic, there's been huge impact on business, and lots of businesses have been restructuring, and these collective consultation obligations will probably bite in many of those restructures.
Yeah, if I can just make one very obvious point. Obviously, the definition wouldn't cover misconduct dismissals or capability dismissals. And secondly, some forms of restructuring like natural wastage or temporary layoffs or even short-time working, unless the short-time working falls within the definition of redundancy, wouldn't be covered. So not every type of business reorganization is covered, but as Mugni rightly says, introduction of new working practices or variation of terms and conditions, if the process might lead to a termination of employment and re-engagement on new terms, is covered, and there's case law which covers that. But I think, Mugni, you've got a few illustrations of this coming up.
Yes, so this is an example taken directly from a case I was involved in for an airport where I was acting for the airport. So here, Heathwick Airport wishes its 400 security staff to move from fixed rotas to flexible rotas to meet the changes in demand during peak times. You can imagine airports and lots of organizations in the travel industry having similar discussions at board level as to how to meet the lower demand in air travel and travel generally. So in that case, the union objected to the proposal. The airport was considering implementing the change through consent, and if no consent, through termination and reissuing fresh terms and conditions. So as the termination and re-engagement is in law a dismissal, and it was likely to affect more than 20 employees in one establishment, the collective consultation obligations were triggered, and they had to have a full collective consultation on that process. So there's a good example of a restructure or a change of terms and conditions, which wouldn't normally amount to a redundancy under Section 139 falling within scope. Okay, so the next question really is, who is the employer? Now you might think this is obvious, but actually, it applies to all sorts of employers, whether profit-making companies, not-for-profit, public and private sector companies, charities, and so on. But because of employers having sometimes quite complex structures, it might be quite difficult to identify who the employer is. So where the employer is a subsidiary of a group, it remains the employer and remains liable even if the decisions are taken at group level. Now, many of you may be familiar with dealing with clients where a subsidiary may employ or do part of the business, but actually it's at group level all the decisions being made about how the business is going to be restructured. But ultimately, the obligation is on the subsidiary business to consult with the staff, even if the decisions are being made much higher up. So you can't plead a special circumstance for breach of collective consultation obligations because a decision to dismiss is taken at a group level and the parent company fails to provide the necessary information. I was involved in a case a couple of years ago, well, quite a few years ago now, where a tier 1 supplier to General Motors at the Vauxhall plant was shut down because the Indian owners in India decided that it was no longer a profitable operation. They didn't consult with anybody and they just made a decision to delete that particular factory. And there was no consultation, no information given. And of course, the employer in those circumstances was the subsidiary based in, I think, Watford, and they could not plead the special circumstances defence because of that provision.
Well, of course, Mugni, we'll see later when we look at the Akavan case that that's another illustration of a decision being made at group level, but in fact it's a subsidiary that's under the obligation to consult. So it's another illustration.
So, who is the employer when there are a number of employers in a group structure? Well, it's possible for lots of companies in a group structure to operate from the same premises, same establishment, as it were. But really, you need to look at the total number of employees proposed as being redundant by that specific employer. And if it exceeds 20, then the duty is triggered. If it doesn't, then the duty is not triggered. And here's a good example of that. So, as I say, Widget PLC operates in Woking, decides to shut down 2 subsidiaries operating from that site. Widget North employing 10 employees and Widget Central employing 21 employees. So Widget Central will be obliged to collectively consult. Widget Central must ensure it's comply with all their obligations. So Widget North wouldn't need to consult on a collective basis under Section 188. Of course, in practical terms, it might choose to do so, but it doesn't need to do so. And its failure would not give rise to any penalty under the statutory provisions. Okay, so we're going to talk about the TUPE exception as well, because the Cameron government introduced some changes to collective consultation, and this is one of them. So, so long as, in many cases, there may be a restructure which involves staff being transferred to a new employer. And before these provisions, Section 198A and 198B, there had to be, usually in parallel or sequential, 2 sets of collective consultations, one under Section 188 and one under TUPE, which really was rather bureaucratic and time consuming. So the government reviewed the law and allowed for effectively overlapping consultation to avoid duplication. But as I've said, certain conditions have to be met to allow prospective employer to elect to do this. And I've set out some warnings there. There's no obligation on the transferor to supply information, and a failure on the transfer to supply information is not a special circumstance, so you can't raise it as a defence. But Antti, I think you've got something to add to that.
Yeah, I mean, essentially, what the provision allows is the transferee, that's the prospective purchaser, to enter into consultation prior to the transfer, assuming that a transfer is likely to take place, assuming, as you've pointed out, Mugni, that 20 or more employees are going to be made redundant after the transfer. And importantly, the outgoing employer, the transferor, has to agree to all of this. That, in essence, is the provision. Obviously, it's slightly more detailed than we have time to cover now, but that's in essence the provision.
So we won't go down a TUPE rabbit hole. Let's move on. So who are the relevant employees? And this is, again, quite important because you need to know who you're obliged to consult with. So the duty applies to employees, so except excluded employees. An employee has the same meaning as under the Employment Rights Act. So it doesn't apply to workers or agency workers or self-employed contractors. Obviously, there may be some challenge about people who are categorized as workers or not employees. And therefore, there has to be a pragmatic approach to that because you don't want to face penalties at the end of the process for not complying with the obligations. But I've noted there, the way in which the provisions in Section 295 are set out is actually in breach of the directive, which applies to workers. Now, the excluded category are fixed-term employees, share fishermen, which is highly relevant, and members of the police service. I think members of the police service are actually not employees because they are office holders. But really, the key one is the fixed-term employees being excluded, so everyone but them. Okay. So what does proposing redundancies mean? Now, that's been tested in case law because proposing is quite an important concept to get right because it is the trigger date for consultation to begin. So is proposing when there's a contemplation, or is it when there is a more formulated plan And that's been doing the rounds in case law for many years. Obviously, unions want to be involved earlier when there may be a contemplation as to whether or not there should be redundancies, whereas employers tend to only want to consult much later on in the process when there is a formulated plan to restructure, for example, which gives rise to redundancies, and to consult with unions then. And so the leading case on that is Akavan, which I've cited there. And the duty to consult arises when an employer has reached a stage where it is not merely contemplating the possibility of redundancy dismissals, but as some form of developed plan. So that was a key finding in that case. I think.
Yes. So if I just come back on that, Mugni, it was argued before the European Court, based on the wording of the directive, that in fact the duty arose at an earlier stage when an employer was contemplating redundancies, maybe putting together the plan at a very early stage. But that was rejected, perhaps surprisingly, by the European Court. And as you rightly say, it is the duty arises. I think one should just say in good time, because there is that qualification before the specific time limits, in good time where the employer has formulated a plan. Now, it needn't be that the plan has been entirely approved. So in a case called Keeping Kids Company, it was when the company put together a survival plan, which was conditional on getting funding from the government. It may be conditional on getting approval from someone or other, but provided the plan is sufficiently formulated, the duty arises. And the important point that's made, in fact, by the European Court and in subsequent cases, that the individuals themselves need not necessarily be identified, provided the numbers of redundancies, proposed redundancies, have been formulated. And as I say, the business plan put together. Now, Mugni, as you rightly say, sometimes in the public sector, unions are involved under the terms of the collective agreement at an earlier stage. But in terms of the directive and its implementation under Section 188, the quotation at the bottom of your slide represents the decision of the European Court in Akavan.
Okay. So I've set out there why it's important. Well, obviously, unions, as I say, want to be involved earlier. Should there be redundancies at all, as opposed to later when there's already a formulated plan? So Akavan clearly is an employer-friendly decision. There's one exception, and that's why I've said it's a warning, and it's UK Coal Mining Limited and NUM, where there is a complete closure contemplated, then the consultation requirement may stretch back into the economic decision-making on the closure itself, on the basis that there's only one decision that has to be made: should you close or not? There's no point arguing about selection criteria if all the jobs are going to go. So that is the one exception which actually applied in my tier one motor manufacturer, parts manufacturer case that I was involved in about 10 years ago. Okay, let's move on to the next topic. So what is the establishment? And again, another key concept that it's important for everyone to understand. And there's been lots of debate about this. The establishment is the local employment unit as opposed to the whole of the enterprise or undertaking. And that's the Usdaw case, which is actually Woolworths. So WW Realization, I think, was the parent company of Woolworths. So the question was whether you aggregate or atomize the undertaking. So here was the whole of Woolworths one undertaking, or was an undertaking the establishment, each individual shop? And of course, if it's each individual shop, then the duty may not be triggered if they don't have more than 20 employees there. So the European Court of Justice said that each Woolworths store was an establishment. So where there are separate entities in an undertaking, the establishment is the entity to which the workers made redundant are assigned to carry out their duties, so not the whole undertaking. So concepts really borrowed from TUPE. So you'd have to look at who's assigned where, and that really is the establishment. Okay, so 20 or more employees. Now, it's a rather arbitrary figure, 20 employees, but that's what the legislation says. So the numbers are critical, and the tribunal will look carefully at whether or not the employer is trying to avoid its obligations by artificially reducing the numbers. There is an example here. It's a tribunal decision, first instance, where the tribunal rejected the employer, saying it wasn't bound by the obligations because it found that there was a attempt to artificially limit the numbers to avoid collective consultation. So that goes back to the directive being given purposive effect because it's an EU directive. So you've got to be careful if the employer is seeking to effect redundancies in batches of less than 20, because questions can be raised that that's not a genuine process, but in fact one designed to defeat the consultation obligations.
So effectively, if the position at the relevant time is that the employer wants to make, say, 50 people redundant, they can't avoid the obligation by placing them in parcels of 20, 20 and 10. However, obviously, the 90-day period is a relatively long period. It's a dynamic period. And if genuinely further redundancies were required during that period, then the fact that consultation is taking place for the first 20 or more doesn't necessarily mean that there'll be a separate obligation to consult if fewer than 20 are proposed to be made redundant during that period, if they're genuinely separable from the original group.
In fact, probably COVID gives us a good example of it, because let's say you've got a restaurant chain in the leisure industry. Because of the initial restrictions and lockdown, they went through a process where they made certain numbers of staff redundant, subject to furlough, I suppose. And then the company gets moved into, or some of its branches find themselves in a tier 3 region where they are unable to open, and therefore they have to have more redundancies in those particular branches. That would be clearly a genuine case of batches of redundancies as opposed to a tactical device. Okay, so now we're going to move on to the duties now. Now, it's very easy to forget this one, but there is a duty to notify the Secretary of State, and there's a picture of a prison there, because if you don't do it, it's actually a criminal offence. So there's specific forms that need to be filled out, which you can get from the department's website. But it's a criminal offence to notify, and directors and managers can be held personally liable and fined for it. So it's important that the obligations are there. And in fact, the duties that you're aware of the duty. And in fact, that's how the government works out partly how many redundancies are anticipated in any given month, because they are collating that data from employers who are supplying it on the relevant form. Moving on, we're going to be looking now at consulting with appropriate representatives. So the duty is to consult with all the appropriate representatives of any employee potentially affected by the proposed dismissals or by any measures. People forget about that, measures taken in connection therewith. So that's really who you've got to consult with, and the appropriate representatives are either trade union representatives, or if not them, then employee representatives. And there are cases where you have to consult with both categories, because the union may not represent a body of employees who are affected by measures.
Just one small point there, Mukni. Of course, that will depend on the scope of the recognition agreement. The fact that someone is not a member of the union, but is within a recognized category, does not give them an independent right. So it's only if there are people who fall outside the union recognition where separate employee representatives need to be elected.
Yes, and I had a case where I acted for an FE college in Nottinghamshire, and they went through a redundancy process and a restructure. The lecturers were all represented by the University College Union, who were consulted, but some of the other staff, particularly admin and clerical staff, were not represented by that union, and they had to elect employee representatives to cover those specific roles, because they were going to be affected by measures by the restructure. Okay, so TU representatives, well, obviously have to be independent of the employer, and there must be a union recognition agreement in place as a bargaining agent. I was in the EAT a couple of years ago, and I was bumped into a friend and a former colleague who's a member of the bar, and he was in the EAT. It was a very embarrassing situation for him, so I'm not going to name him. But he and his opponent had managed to get to the EAT in a collective consultation case. And the first thing the EAT judge said was, well, is this a recognized union? Is there a union recognition agreement? Nobody thought to look. And so they just presumed it was. There was no recognition agreement, so it wasn't a proper party for collective consultation. And as a result, the whole thing was thrown out. So it's important to check that if you're advising, to have a look at the union recognition agreement. I've certainly been involved in cases where they say, oh yeah, we've been doing this for years, but it's important really to go back to the recognition agreement, because it might only deal with certain categories of employee, in which case the union may not be the right body to speak for different categories who are not within scope of the recognition agreement, just like the Nottinghamshire FE college that I was involved in. And of course, if there's more than one union recognised, you need to consult with each of them. You can't just pick and choose, and that can actually cause all sorts of problems as well, because any union will have standing, which is under a recognition agreement, to bring a claim for a protective award for failure to consult. So if there's no union, then usually you have to consult with employee reps, and they must be an employee of the employer. So union reps don't need to be employees of the employer. They can be, so long as they're a recognized union official, that they can be involved in it. I had a case very recently, actually, where the employer wanted to exclude the union regional manager, regional officer, on the basis that he wasn't an employee. And I had to say, well, you've got no right to do that. As much as you may not think you will contribute, you don't want to be in breach and then end up having to pay a protective award. So only employee reps must be employees. And there are two types. Sometimes you have a joint consultative committee or staff or management forum or works council, so a pre-existing mechanism. Or secondly, you might need to set up employee reps through election for the purposes of the consultation. And if you're in any doubt about whether any joint consultative committee has sufficient remit, then you should really hold an election. Okay. This is a no-brainer, but it's important to remember this. But the duty to consult can only commence when the employee reps have been elected. So you need to get on with it, because if you're the business, you want to affect your changes sooner rather than later. So delay is not really in your interests. Of course,
if I can just mention section 1887A does say that where the employer has invited the effective employees to elect a representative, and the information was made long enough before the time when consultation is required, then in such circumstances, consultation should begin as soon as practical. So that deals with the situation if, in fact, it is, as you've got on the slide, the employees who cause the delay in electing the representatives. So that can impact on when consultation starts.
Yes, that's right. But really, I mean, one of the issues that I've had as a practical issue is that that I've advised on is, well, how do you go about setting up an election when people are unable to come into work and so on? Now, we're all very familiar with lots of internet surveys and internet elections. The ELA does it. The Electoral Commission gives lots of advice and support on anyone who wants to conduct an election. They can actually done relatively easily, and anyone with a smartphone is able to access them, which I presume would be most people in the workplace. Therefore, really, there shouldn't be any delay. It should be relatively straightforward to set up. If the employers fail to elect reps, this is subsection 7b, then the employer should inform the affected employees directly of the proposed redundancies, but there's no duty to consult. So remember, there are two separate duties: to inform and consult. It can't consult because there are no employee reps, but it still has the duty to inform. And if it doesn't inform, then of course it'll be in breach. I've just set out there the safeguards for employee reps. Well, obviously, they need to have access to facilities. Now, in this sort of era where you can't have a town hall meeting with everyone sitting in one large room, then the employer should really make facilities available for Zoom conference calls and things like that, or perhaps make sure that the premises are sufficiently safe to allow for surgeries for consultation purposes. The usual things that we need to do to keep workplaces safe during a pandemic that the government's given lots of advice on. So there is the access point. Then, of course, obviously a union rep or a trade or a employee rep can't suffer detriment for carrying out that role, or be dismissed for it because it's an automatic unfair dismissal. And they're entitled to paid time off in order to discharge their functions. So these are the basic rights that an individual rep will have. So the next question I want to deal with is, who are the affected employees? So they're not just people at risk of dismissal, as I mentioned, but also those affected by measures. So the sort of de minimis test is that it's any employee whose working conditions will be altered in more than a de minimis way. So I gave the example there of 40 lecturers at risk of redundancy at a college, but due to the restructure across the whole college affecting all lecturers, need to consult with all the lecturers.
Just one point there, Mugni. You say working conditions. It could be working conditions or role, which is illustrated by the example you give at the bottom of the overhead.
Okay. Right. Right. So we're going to move on to the duty to inform, which is one of the core duties. I've set out on that slide the things you need to inform the employees about. So obviously, reasons for proposed redundancies, number of likely dismissals are key, total number of employees of those descriptions employed at that establishment, and the proposed method of selecting for redundancy. And there are other points there as well. So you need to look at that provision and make sure you've complied with it when the letter goes out to inform. And it has to be supplied in writing to the relevant employee and TU rep. Now, in the Nottinghamshire FE College, one of the unions took the point that there was not proper information provided because it wasn't sent to the union's designated address. Even though everyone knew about it, it was emailed across to the local union rep. It wasn't sent properly, and therefore there was a argument about a failure to fully inform. Also, and this is the Susie Radkin case, it must be provided before consultation starts, obviously, so that appropriate reps are fully informed to embark upon the consultation process. Sorry, go on.
A couple of points there. The overhead obviously sets out the duty to inform. Where we refer to the proposed method of selecting for redundancy, obviously one of the important areas when we come on to consultation is that consultation gives the parties an opportunity to agree the redundancy selection criteria, and that's important in any redundancy exercise. And in terms of the method of calculating any non-statutory redundancy payments, what that's referring to is whether there are going to be any payments beyond the statutory minimum, in other words, enhanced redundancy payments.
Now, on this slide, I've actually set out some warnings, two of which I've already dealt with. The third one, and it touches on what you just said, in that case of Green and Sons and ASTMS, they said selection criteria to be agreed with the unions. That was found to be inadequate information because there has to be some sort of formulated plan. So it could be selection criteria based on a matrix selection process involving performance, looking at PDRs and things like that. So they have to put something concrete down, which is then subject to consultation. So you can't just leave it up in the air like that. Okay, so the duty to consult, which is the next core duty, it's worth looking at what the statute says. So the consultation shall include consultations about ways of avoiding the dismissals, reducing the numbers of employees to be dismissed, and mitigating the consequences of the dismissals. Now, I was asked quite recently to advise this employer, and they were asking this question, right? Okay, we're proposing on dismissing 30 people as redundant, but what if we decide not to make any redundancies at all? Is the duty triggered? And I said, well, that's the whole point of consultation. You've got a concrete plan that you need to reduce your headcount by 30, but of course, part of the consultation might involve reducing those numbers because that's what the statute requires you to do. So obviously, if you're proposing 20 or more and the reduction leads to fewer than 20 being made redundant, the duty still, the duty to collectively consult is still there because, of course, the starting point is where the duty bites, not the end point. Because in theory, you could have a situation where you're contemplating making 500 people redundant. You've got a 45-day consultation period, and during that consultation period, a rescue deal is found for the business, and as a result, there are no redundancies. That wouldn't negate the obligation to actually consult during that period. It's in fact shows that consultation may have actually led to fruition. So,
as you've pointed out earlier, one way of avoiding the dismissals may be changes in terms and conditions. And of course, as you have rightly pointed out already, in the BA situation, the initial proposal was to make redundancies, but then that changed to propose variations in terms and conditions. So that's one of the potential ways of avoiding dismissals.
So going back to almost the Akavan situation, the duty is not to consult about the underlying reason for redundancy. Unions always try and do this, say, well, if you've done this and you've done that, then you wouldn't need to have so many job losses. But it's not about how to mitigate the effects of that managerial decision. So common things, voluntary redundancy, natural wastage, redeployment to other work. You can also look at reducing hours. We've got the new tier 3 on tier 2 sort of quasi furlough scheme where people's hours are reduced and they work, I think, up to 20%. They're paid up to 73% of their salary if that happens. So there are lots of different options available, and I suggest to employers that they keep an open mind as to what they can do. But really, if the reason for the redundancies is to increase cash flow and or reduce headcount and therefore make savings that way, then look at exploring other issues that can reach the same end and retaining your employees. So, as I say, compulsory redundancy should be a last resort, and the duty to consult. The one exception about the underlying reason is when there's a total closure. That's the Aztor case that we mentioned. Sorry, the NUM case that we mentioned. Okay. If there is a unexpected or immediate closure, which is possible in these very uncertain times, there's still a duty to consult, if nothing else, on mitigating the effects of the closure. So if the government announced a new tier 4 tomorrow, which meant that lots of businesses, your local gym, had to close immediately, then it can't still just do absolutely nothing and say, well, it's not our fault. The government closed us down and therefore we had to make redundancies. They still have to do as much as they can to consult with staff, if nothing else, on trying to give staff some comfort as to what might happen, whether or not there's any enhancement to redundancies, things like that, whether there are options to redeploy to another branch. All those sorts of issues need to be looked at. So you're really unlikely to get away with doing nothing, because even the special circumstances defence requires you to take as much or do as much as you can to prevent the employer from fully discharging its duties. Okay.
And of course, at the moment, these policies are generally discussed at least a week or two in advance. So it's unlikely that something is going to be announced without any prior discussion or consultation.
Well, I've just done an ET3. It's not collective redundancy. They got rid of it's a business. It's a catering company that provides catering for events, and of course, it's been very adversely affected because lots of events have been cancelled, and it made 12 redundancies recently, and there's an ET3 that I drafted 2 days ago on it, and they just made a decision that they were going to get rid of 12 people, and they didn't actually have any consultation. So at management level, at board level, they decided they've got to have a headcount reduction, and they then just told the staff, the 12 they'd selected, well, you're gone. No consultation whatsoever. Now, some of them don't have qualifying service. But most of them have brought discrimination claims as well, because they say that the older workers, I think there were 3 claimants who are claiming age discrimination, saying they were selected because they were older and more expensive. It would have been a lot simpler, even in those circumstances, where they had to make a very quick decision to inform the staff that they were contemplating redundancies, have a consultation meeting. It could all have been done within 3 or 4 days, certainly within a week. Then they could iron out any issues. And if there are issues with people who might allege discrimination and so on, either address those concerns or think again about how they're approaching the process. But now they've got 3 cases now out of the 12. I suspect they'll have some more because people have got nothing to lose. They've been made redundant. They haven't got jobs to go to. So, what are they going to do? They're going to bring a claim if they think that there's been a failure to implement a legitimate process. And there was no process. So all of them almost certainly will be able to establish that there was a procedural unfairness in that dismissal. And then you're into Polky territory to try and reduce the award. Really, do what you can in circumstances where you may not be able to comply with all your obligations. And I say here, consultation must be meaningful, So it can't be just paying lip service. And it has to therefore take place before notice of termination are issued, which is...
In fact, Mugni, there's a European case on that called Junk and Kuhnel, 2005 IRLR 310, where the European Court makes the point that if you're already giving people notice, then there's not much point in consulting after the event because you've decided who's going to be terminated.
Well, as a matter of contract, if you give notice of termination, that is an unequivocal act terminating the employment. You can't revoke that. Employers seem to think that they can at will, but actually the employer can stand by and say, well, no, you've given me notice. That notice took place before any consultation, and as a result, I'm entitled to get a protective award for failure to consult. And as you mentioned already, the whole point of consultation is trying to get an agreed solution with the appropriate representatives. That's really important because I've got a case at the moment. It's another college, this time on the South Coast, where the unions were warning that the selection process that the college proposed was flawed. And the college carried on nonetheless without an agreement. And they've now had 30, I think, or 25 claims. And in all of them, there is a fundamental problem with the selection process. And the problem was this: one part of the selection matrix involved people giving themselves self-scores, which were then not moderated. So some people gave themselves full marks for everything. Some even went beyond the full marks and gave themselves 150% of the marks, and which meant that if you were more modest and humble in your self-assessment, you are more likely to be made redundant. So the spreadsheet they used was completely flawed, and then they tried to change it and bring in moderation after the event, but then the whole system had fallen apart. They should have listened to the union and they should have agreed a solution to that, but they didn't. And as a result, they've got lots of claims that are now being defended with limited prospects of success.
Technically, I think what the case law says is that you don't need to reach an agreement, but you need to give consideration to the representations that are made by the union or the employee reps and give a rationale for rejecting them. So,
well, the BA example is a good example. Yes, the unions weren't very happy. The pilots' unions weren't very happy with the pay cuts and a reduction of benefits. But it meant the saving of lots of jobs, which would otherwise have been made redundant. And so, agreeing with the unions, even if they're taking a difficult line, is actually really quite important because it can make life a lot easier for you in getting...
Well, and also, of course, as you've touched on in your example of things going wrong, if the selection criteria are agreed, that when it comes to individual selection and individual consultation, you start from the basis that the selection criteria are agreed. And all the individual can argue is that the selection criteria were unfairly applied or that there was alternative employment or matters of that kind. But that's why it's very useful to agree the criteria.
Okay, one small point is, when does consultation have to start? Well, that's quite important to understand. So it must take place, as you said already, Anthony, in good time before the redundancies. But there's some minimum time periods, so not less than 45 days. It used to be 90 before the changes introduced by the Cameron government. So 45 days before the first dismissals take effect. And we know take effect means when notices of redundancy are sent out, where there are 100 or more proposed dismissals, or 30 days in every other case. As I say, case law has established, and we've just talked about it, the consultation must begin and end before any notices of redundancy have been issued. Now, it's easy to forget, as I say, that there is it's got to start not less than 30 or 45 days. But it doesn't need to end at the end of that period because there's no prescribed duration. You've got to try and reach an agreement. That's the sensible, pragmatic way of looking at it. If you reach agreement quite early on, then get on with it. You don't need to wait the full period. If you haven't reached agreement, then of course you've got time to negotiate. Now, it's sometimes easy to think that you're not going to reach agreement, because my experience of doing this, and I've been involved in collective consultation cases for many years, is that the starting point for the unions is quite bullish. It always looks as though there will not be agreement at the beginning. The unions take quite a robust line, and then it's easy to think, well, there's not going to be agreement here. But very quickly, when they realise that if they don't reach agreement, then everything's out of their control, and you can still plough on, they start becoming more sensible. Obviously, depends on the union itself and indeed the individuals concerned. But don't fall into the trap that there's not going to be an agreement, therefore you're going to just plough ahead, when really it's posturing in the first week or so to try and test your mettle as to whether or not you are going to roll over and avoid redundancies altogether. So persevere and try and reach an agreement, because that's the best position to be in for all the reasons we've highlighted. And the final point on consultation, and again, we've touched on this, there has to be collective consultation in the appropriate cases. But don't forget individual consultation under Section 94, because if you fail to have individual consultation, in other words, once you've identified those at risk and they've put them through a selection process, you don't have a meeting with them to say, okay, what do you have to say about it? Then almost invariably that will be an unfair dismissal in most cases. The college where everything on the South Coast where everything went wrong, again, they failed to have any individual consultation, because what they did was they then sent a letter out to those who were selected under the matrix selection process that they scored the lowest, and therefore in their pool, and therefore they were dismissed.
Yeah, I mean, I've noticed quite a few situations in the current COVID environment where collective consultation has been complied with, but then, as you've just said, Mugni, individual consultation is overlooked. And
there isn't,
although, as you rightly pointed out, there may be cases where it's open to the employer to say, well, even if there'd been individual consultation, that individual would have been selected, a Polkey type argument. Nonetheless, they're still open to the risk of a finding of unfair dismissal, other than in very highly exceptional circumstances.
Yeah, I think that's right. Okay. So what are the remedies? Well, obviously proceedings in the employment tribunal. There's possibility of high court injunctions. I think, were you going to say something about that, Anthony?
Yeah, I was. I mean, I agree with you for raising that as a bullet point, but I think it's highly unlikely, because there's case law which says that where the remedy is prescribed in the employment tribunal, then there shouldn't be an alternative remedy in the High Court. I know, Mugni, you will probably come back at me on this and say, well, there historically are some cases involving the closure of the mines during the NUM dispute in the 1980s, where injunctions and declarations were sought. And it is true that in the public sector, where there is an expectation of consultation, those alternative remedies may be available. But I'd say generally, the principle is that the remedies set out in Section 187 and 188 mean that the claim can only be brought in the employment tribunal.
I think the reason I put a question mark there is because I think this area of jurisprudence has not been fully tested in the modern era. And although the High Court may be unwilling to get involved, it depends on the type of situation we're looking at. Because injunctions can also be brought about through judicial review. So thinking out aloud, we've got Public Health England, which is going to be abolished or restructured, which was announced by media, because I don't think the chief executive knew that he was going to go. There are judicial reviews in respect of that decision. And so, you can see how that could feed into collective consultation, which must be going on at the moment. Okay. Obviously, declaration for breach in the tribunal, protective award, that's the bit that would concern any employment lawyer, and obviously any unfair dismissal can be brought by the individual employees. So this is the complicated bit as to, well, who can bring a claim for breach. In essence, section 189 says it's the employee reps or the trade union reps. They're the main people who've got standing. So sometimes you see these claims brought by individual affected employees, but actually their standing is limited where there's been a breach and it relates to the election of employee reps, or where there is a breach of duty where there are no employee reps. So really limited scope for an individual to bring the claim. Really, it's a union that will bring the claim. And in the claims I've been involved in, what tends to happen is that the union will bring the claim, the collective consultation, protective award element, and then the individuals who are complaining about stuff, for example, in the airport shift rota case, we had the union bringing the individual collective consultation claim, and then 5 or 6 individual female members of staff who brought indirect sex discrimination claims because they were they had children who they had childcare responsibilities, which was incompatible with the change in terms and conditions. And they also brought unfair dismissal claims because they're all dismissed and re-engaged. So that's the sort of picture of litigation you get in these circumstances.
It's a rather strange situation because the union or the elected rep brings the claim, but once the claim is determined and upheld, if the employer doesn't pay the penalty, then the individuals bring a claim to enforce the protective award.
The individual has the right to.
Rather strange process, but that is the process.
Well, the whole protective award point is rather old and fairly draconian, because for a start, as I say on this slide, if there's a breach, then there's a discretion to make a protective award, and it can be awarded to dismissed employees or those who are still employed, but where there's a proposal to dismiss during the protected period. And the protected period is a period of 90 days from when the first dismissals take effect. Now, that 90-day period is far in excess of the 30-day period if it was only a small collective consultation, and now double the longer period of 45 days for for 100 plus employees. So it has no real bearing, at least when it was 90 days. And if you're dealing with a very large redundancy, it reflected the 90-day consultation period, but it doesn't. So it's actually quite punitive from that perspective, potentially. And of course, it applies to a whole wide range of employees who are caught by the collective consultation process. So, those who are still employed where there's a proposal to dismiss. So in other words, people who haven't even been dismissed yet can get a protective award. There's one thing saying, well, there's been a breach of consultation, and those people who've been dismissed should get this award. But what about those who are still employed? They're getting a windfall. In terms of protective awards, the thing to remember is that there is no statutory cap. It's based on a week's pay, actual pay, excluding bonus. And it can lead to a 90-day sum for each qualifying employee. So the figures can add up very quickly. The tribunal has to take into account mitigating factors. So inadvertent breach or immaterial or technical breach can be a mitigating factor. So one example we had in the case I was talking about, where the letter informing of the proposed redundancies, wasn't sent to the designated union address, but actually emailed across to the local rep. That was seen as being an immaterial or technical breach, and therefore didn't merit any protective award. But it does depend on tribunal discretion, ultimately. And we know about discretion. It's notoriously difficult to appeal. So if the in that particular case, for other reasons, there was I think a 3-week protective award, which applied to, I think, about 50 people. So that's a lot of money. And although 3 weeks is very shorter than 90 days, there's no prospect really of overturning that decision. So
I mean, one illustration, we'll look at it later, is the company kids case, where the EAT,
the kids company case, yeah, the
tribunal award, based on the fact that a special circumstance arose during the protected period. But we'll come on to that in a moment.
Okay, well, I'll let you talk about that when we get to that slide. So, and the fact that the employer's got no money to pay is irrelevant. So that's not a factor to be taken into account. So we move on to special circumstances. And if you look at the actual wording in the statute, you'll see that it's actually quite limited. And the limit on special circumstances is that it can't be reasonably practicable for the employer to comply. It's a very high threshold, and the employer shall take all such steps towards compliance with the requirement as reasonably practicable in those circumstances. So, it has to be a special circumstance, and it can't be reasonably practicable. Well, we know how high the threshold is for that. Recently, there's been some case law on it, but going back to even the late 70s, insolvency, for example, itself is not a special circumstance. It's only capable of being exceptional if it's sudden or there's an unexpected disaster. So kids company, do you want to take over, Anthony?
If I just quickly mention, I mean, in that case, the tribunal, as I've mentioned earlier, and the EAT said that there was a breach of the statutory provisions and that the plan was formulated on the 12th of June. But during the protected period, there was the police were called in, and the police were investigating a variety of matters, as the overhead says, including fraud, but also breach of safeguarding responsibilities, which an organization which specializes in the care of children is obliged to follow. And therefore, the EAT indicated that the tribunal was wrong to award a protective award for the full 90 days, but should have taken into account the date when the police were called in, which was just over a month, I think 6 weeks after the plan was formulated, and the protected award should have been limited accordingly. So I think the interesting point there is that a special circumstances argument can arise as a defense to an award of compensation during the protected period.
Now, I've put some warnings on that slide. So obviously we've touched on this, that's the Portugal case. You've got to do what you can, even if there are special circumstances, meaning you can't comply with all of your obligations. And you've seen the statute which requires you to do that. But some examples from cases that I've seen, well, ignorance is no defense. You can't say, well, you didn't know, nor is mistake, which is easily done in counting the number of proposed redundancies. They're not a special circumstance, nor is the fact the parent company has failed to provide information, which we've talked about before, or that consultation may be futile with redundancies is inevitable. That's not a special circumstance. And it is the defense of last resort, and generally will fail. So in most cases, really, you don't want to be having to rely on that defense, because it's very much an uphill struggle. Which then brings us to the circumstances of lockdown and COVID. Is it a special circumstance? Well, Anthony, what's your view about that?
Well, I have to say the real problem with these things, as you know, is that the tribunal determines these things with the rose-tinted spectacles of hindsight. And what might seem a special circumstance at the time is not always upheld subsequently. So my feeling is that COVID lockdowns or COVID tiers are not probably going to amount to a special circumstance. But even where they do, Mugni, as you so rightly pointed out, that will not exclude the obligation to consult in its entirety. It will largely be a factor saying, well, as this came about fairly suddenly, the amount of consultation is more limited. So my practical advice would be, despite COVID, try to follow these obligations.
I think I agree with you entirely. Despite COVID, try and follow these obligations. Even if you can't meet all of them, if there's a genuine attempt to try and go through consultation, at least if there is a special circumstance defence, you'll have an opportunity, or you'll be in a better position to actually make it out.
And if I could just add one other point on the reality, I mean, as we know, the Chancellor has offered a lot of what broadly can be called subsidies in the short term, and they're, I think, now likely to go on until the spring. And the real impact, I would suggest, is going to be felt after those subsidies are withdrawn and the economy hasn't fully recovered. And in that situation, it's going to be very difficult to argue special circumstances, because companies and organizations will have quite a long time to prepare for this and formulate their response. So whatever the position on the introduction of the original lockdown in March and the tiers more recently, I think special circumstances are unlikely to apply when hopefully this terrible situation comes to an end, but business is still feeling the effect of it. I don't know what you think, Mugni, on that.
No, I agree with you entirely. I think we're in very uncertain times. Different sectors are being affected differently. We you know, I suspect there'll be far more redundancies occurring over the next few months, despite all the different schemes that the Chancellor set out. Even if there are no actual redundancies, but businesses are taking steps to restructure their workforces or restructure the way in which work is delivered, then of course, arguably the consultation obligations will apply because of the wider definition of redundancy under Section 195. So I think for the foreseeable future, there is a prospect of lots of change within the economy, and this is these obligations are fundamental to ensuring you get it right. So that probably brings to an end our talk. It's a sort of whistle-stop tour to give you enough information to be able to advise, understand what the obligations are. We have gone through the slides. The slides are available if you contact number 5 Chambers. Then of course we can get some slides over to you. So Anthony, I just want to thank you for your contribution. It's been very helpful, and I want to thank you, thank all the listeners out there for your for your attention. Thank you.
Thank you to everyone.